back to Winning Isn't Easy. What are the common mistakes that ERISA disability carriers or plans make in a denial or termination of benefits letter? It's done to get that denial or termination letter from your ERISA disability carrier or plan. You read it cover to cover. The letter's confusing. Your medical records look like they've been picked over like a grocery store before a hurricane. There are lots of mistakes that violate ERISA regulations. And in my view, these mistakes are the starting point for filing a winning appeal letter and getting your benefits. What are those mistakes that are made about the specific reasons for the denial or termination in reference to the specific policy or plan terms? And this is where I start. So the denial or termination letter may start out by saying that your claim is denied as of a certain date and no future benefits are payable. It might recite the date you claim you were disabled, the medical conditions you claim as the disabling basis of your disability claim, your occupation, the period of benefits that were paid, before it then starts quoting various provisions of your policy or plan that were the foundation of the denial or termination. Now, let's talk about the most commonly cited policy or plan provisions. They will cite, among other things, the pre-existing condition clause, the definition of occupation, the definition of disability during the own occupation period, the definition of any occupation for that period of disability, the definition of objective medical evidence, the definition of subjective medical condition limitations, the definition of mental nervous limitations, the definition of reasonable and necessary medical treatment. So let me give you an overview. And this is an example. You might claim that you're disabled as a result of a heart attack and you were employed as a systems engineer at the time you became disabled. The carrier plan may have paid your benefits for 2 years under the own occupation standard of disability. Now the standard of disability has changed from an inability to do your own occupation to an inability to do any occupation by virtue of your education, your experience as a systems engineer, and your restrictions and limitations. The denial or termination letter doesn't always quote the whole definition of any occupation. In fact, it may even use the wrong definition of any occupation because of another document that you want to get called the summary plan description. It may have a different definition of occupation than that in the policy or plan. So they're denying your claim applying the wrong definition of any occupation. That can be the start of an appeal. But let's say for this example, the definition of any occupation is correct. While the regulations require that they tell you about the specific reasons for the denial or termination, that's not often the case. The letter will often inaccurately or incompletely summarize your medical records. They'll cherry pick your medical records in a way that justifies a claim denial or termination. The carrier or plan may misinterpret test results and then claim that the results mean that your doctor's restrictions and limitations aren't valid. Then they will claim that their liar for hire doctors who have reviewed your medical records have reached a different conclusion. They won't identify their doctor. They won't tell you what questions they asked of the doctor, what information they gave to the doctor, whether the doctor consulted with your doctor, whether they asked the doctor to rewrite the opinion letter to make it more favorable to them, or even how their doctor reached the conclusion that you could allegedly even do a sedentary job that would allow you to do any occupation. Now, these are just some of the common violations of the regulations. But to get there, you obviously need to request a copy of the disability carrier's claim file they have on you and a copy of the policy of the plan so that you can literally be reading the claims file, the definition of applicable policy terms, and that denial or termination letter side by side. Got it? Now, I want to tell you that these violations get worse, and we're going to talk about that in our next episode. Let's take a break.